Look, we've all been there, right? The neighbor's dog that never stops barking, the DIY enthusiast starting their power tools at the crack of dawn on a Sunday. You know the drill. The law has to step in and draw a line somewhere between the normal give and take of living next to other people and an interference that's so bad it actually becomes illegal. And that line, well, that's exactly what we're exploring today.
This video was created with AI to support SQE1 study. We are independent and have no affiliation with the SRA, Kaplan, or the SQE. We do not share exam content, and our videos are for informational purposes only and should not be used as legal advice. Please check and refer to primary legal sources and recommended prep guides as you study.
All right, hello and welcome. If you're gearing up for SQE1, today we're going to tackle a really crucial piece of that puzzle by breaking down the law on nuisance and that very particular, very important rule in Ryland v. Fletcher. Okay, let's get right into it. So, these are our three main players today. You've got private nuisance, which is all about protecting your own patch, your land. Then there's public nuisance, which is much broader. It's about protecting the community. And then you've got this special one, the rule in Ryland v. Fletcher. Think of that as the high-stakes, strict liability rule for when something dangerous gets out. We're going to break down each one. So first up, private nuisance. And here's the number one thing you have to get for your exam. This tort isn't about protecting you as a person. Nope. It's all about protecting your rights and your interests in your land. That's the key. Here we have the legal definition. Now, inside that definition are three kind of magic words you've got to lock in for the exam: continuous, substantial, and unreasonable. A one-off party? Probably not a nuisance. But a massive party every single weekend? Now we're talking. The interference has to be more than just a minor irritation, and, this is the most important part, a court has to decide that it's unreasonable.
Right, so how on earth does a court figure out what's unreasonable? Well, it's not like there's a simple checklist they run through. It's much more of a balancing act. The judges will weigh up all these different factors. Are we in a busy industrial park or a quiet little village? Is this noise going on 24/7, or is it just for an hour a day? And crucially, is the defendant doing it on purpose just to annoy someone? Let's zoom in on a couple of these.
The clatter and noise from a sweet factory might be perfectly fine in an industrial area like Bermondsey was back then, but that same noise next to a doctor's office in a fancy, quiet neighborhood like Belgrave Square? No way. That's a nuisance. So you see, context is everything. And here's another great one that shows how your motivation can change everything. In Christie v. Davy, you had a music teacher giving lessons. The neighbor got fed up with the sound and started deliberately banging pots and pans against the wall whenever a lesson was on. The court basically said, look, the music lessons were a reasonable activity, but the neighbor's banging, that was done out of pure malice, and that's what made it an unlawful nuisance. Okay, pay close attention here, because for the SQE, this slide is pure gold. Who can actually sue? The big case, Hunter v. Canary Wharf, made it crystal clear. Private nuisance is a tort against land, so you must have a legal interest in that land. You have to be an owner or a tenant. If you're just a guest or a kid living with your parents, you might be annoyed, but legally, you can't sue. And who gets sued? Well, usually it's the person making the nuisance. But as Sedley Denfield showed, if you're an occupier and you know there's a nuisance on your property, even if someone else created it, and you do nothing about it, you can be seen to adopt it and you'll be liable. Okay, let's switch gears and talk about something a bit different. A very specific type of nuisance that's so unique it has its own name, the rule in Ryland v. Fletcher. Now, don't think about ongoing annoyances here. Think about a one-off escape of something really dangerous that someone decided to keep on their land. The key phrase you need to remember is strict liability. And this is it, the heart of the rule: keep it in at his peril. What that means is, it doesn't matter if you were careless or not. It's not about proving fault. It's simply about the fact that you chose to store something risky, it got out, and it caused damage. You are liable. So to make a successful claim, you have to prove all four of these things. Think of this as your four-step for a claim. You need every single one of these. Let's dig into what is probably the trickiest one on that list. What on earth is a non-natural use of land?
Now that term non-natural use has caused a lot of headaches over the years, and the courts have really narrowed it down. The big case here is Transco. The House of Lords said that today, for something to be a non-natural use, it has to be extraordinary and unusual, and carry some exceptional risk. So, piping a large amount of water to a block of apartments, the court said that's perfectly normal and natural in this day and age. Storing huge vats of chemicals in an industrial plant? Yeah, that's probably getting into non-natural territory.
All right, let's round this out with our third and final tort, public nuisance. As you can probably guess from the name, we're moving away from disputes between neighbors and into things that mess things up for a whole section of the community.
So the key thing here is scale. We're talking about something that impacts a class of people. A good example is the PY Quarries case, where dust from a quarry affected an entire village. But here's the exam tip. For one person to bring their own civil claim, they can't just be annoyed like everybody else. They have to prove that they suffered special damage, some kind of harm that was worse than or different to what the rest of the community had to put up with.
The Tate and Lyle case is the perfect way to understand this. So, the defendant built these ferry terminals, and it caused the riverbed to silt up. This made it hard for all boats to get through. That's the public nuisance right there. But Tate and Lyle had their sugar refinery upriver, and they had to spend a fortune on extra dredging just to get their big ships in. That extra financial cost was their special damage, and that's what allowed them to sue and win. Okay, so now that we've got a handle on these three torts, we need to talk about the get-out-of-jail-free cards, defenses, and also what happens if you win. What are the remedies? This stuff is super important for problem questions.
Here's a quick-fire list of the big ones. Statutory authority is huge. If an act of parliament basically says you can do the activity, that can be a complete defense. Act of a stranger, which we're about to see in action, is a really key one for Ryland's for Fletcher claims. And just remember, that last one, prescription, the 20-year rule, that only applies to private nuisance.
So what can a defendant actually do? Well, even if an activity is technically causing a nuisance, the law provides some pretty powerful shields. Let's start with what is probably the strongest one of them all. Think of statutory authority as the ultimate trump card, handed down directly from Parliament. If an act of Parliament says you can do this, like build a new railway, then any nuisance that is an unavoidable result of that activity is basically excused. But it's not a get-out-of-jail-free card for being sloppy. The case of Allen v. Gulf Oil really nails this down. So Parliament gave the green light to build an oil refinery, but didn't spell out that they could operate it. The locals complained about the smell and noise, but the court said, well, what's the point of building a refinery if you can't run it? The permission to operate was implied. For your exam, just remember that key limit. The nuisance has to be unavoidable. If the defendant could have done it more quietly or cleanly, the defense is off the table. Okay, next up we have prescription. This is basically the, hey, I've been doing this for 20 years and nobody said a word defense. It sounds pretty simple, right? But there is a huge, critical catch when it comes to starting that 20-year stopwatch. And that brings us to the famous case of Sturgis v. Bridgman. So you've got this candy maker, his machines have been clattering away for ages, no problem. But then, a doctor builds a new consulting room right next door, and suddenly, the noise is a big issue for him. The court said the 20-year clock only started ticking from the moment the noise actually became a nuisance to the doctor. This case also gives us a golden rule for the SQE. Coming to the nuisance is not a defense. You can't just say, well, you moved here, you knew I was noisy. We've also got a couple of other key defenses for when things are just totally out of the defendant's hands. Act of a stranger is for when, say, a trespasser causes the problem. And act of God is for some kind of crazy, unforeseeable natural event. The connecting idea here is that the defendant couldn't have possibly seen it coming or done anything to prevent it.
So, let's say your claim is successful. What do you actually get? Well, the court has a few tools. The main one, the primary remedy, is an injunction, which is just a court order telling the defendant to stop what they're doing. The court can also award damages, which is cash, to compensate you for the harm. And finally, there's abatement. That's a limited right to self-help, but you have to be really careful with it.
This is where we get into remedies. You see, proving the nuisance is just step one. The remedy is what really counts. The two big ones are injunctions and damages. An injunction is a really powerful court order that basically says stop doing that thing now. It's all about preventing future harm. Damages, on the other hand, well, that's money. It's compensation for the harm that's already been done. So the real choice is, do we stop the problem or do we pay for it? Now, the way courts think about this has really changed thanks to a huge case called Coventry v. Lawrence. It used to be that if you proved nuisance, you pretty much got an injunction automatically. But not anymore. Now the court has discretion. It can perform a balancing act and decide to award damages instead. It'll look at things like the public interest. So if shutting down a factory would mean hundreds of people lose their jobs, a court might just say financial compensation is the better way to go. So if the court does award damages, what are they actually for? Now, this is a critical distinction for the SQE1, so pay close attention. In private nuisance, damages are for harm to your land, either physical damage or what we call loss of amenity, which just means you can't enjoy your property as much. Critically, you cannot claim for personal injury in private nuisance. But, and here's the twist, in public nuisance, if you can show you suffered special damage, meaning harm that's worse than what the general public suffered, then you can claim for personal injury. There's also this interesting self-help remedy called abatement. It basically means you can take reasonable steps to stop the nuisance yourself, like trimming your neighbor's tree branches that are hanging over your garden. The courts aren't huge fans of this because, it can easily escalate into a bigger fight, so it's really only for simple, clear-cut cases. All right, now for something a little bit different, but it's closely related. It's the rule in Ryland versus Fletcher. This is a very specific type of legal claim that deals with one-off escapes of dangerous things that someone has brought onto their land. So for a claim under this rule to actually work, you have to tick 4 boxes. 1, the defendant brought something onto their land on purpose. 2, this was a non-natural use of the land, something extraordinary or unusual that adds extra risk. 3, the thing they brought is likely to cause trouble if it escapes. And 4, it has to actually escape and cause damage. But wait, there's more. The courts added a 5th hurdle in the Cambridge Water case, foreseeability. The defendant is only on the hook if the kind of damage that happened was a reasonably foreseeable result of the escape. This was a really big deal because it pushed this rule much closer to the principles of negligence and nuisance.
Okay, theory time is over. You've soaked up the rules. Let's put this into practice and see what a question might actually look like on the SQE. Read the facts and think hard about those defenses we just covered.
Take a second, read the options, and make your choice. Okay, the correct answer is D. Let's quickly run through why. A is wrong because, as we know, coming to the nuisance is not a defense. B is wrong because that 20-year clock only starts when someone is actually there to be bothered by the nuisance. C is not quite right because while it's not a defense, the long history of the factory might influence the remedy. So D is the best answer. It perfectly applies the rule from Sturgis v. Bridgman. Ready for round 2? Same deal. Pause and have a think. And the answer is B. This is a textbook example of the act of a stranger defense. Now, even though we call the rule in Ryland's strict liability, it's not absolute liability. The deliberate, malicious act of a trespasser breaks that chain of responsibility for the landowner, as long as the owner wasn't negligent in, say, leaving the gates wide open.
Okay, we have covered a ton of ground. So, to wrap things up, here's your final cheat sheet. This is perfect for that last-minute revision to make sure you've connected all the key principles to the must-know cases.
So what's the big takeaway here? All of these torts are about balancing the rights of one person against the rights of another. For your exam, you need to know the specific elements for each tort, you absolutely have to know the key defenses, and you need to have these leading cases at your fingertips.
For defenses, remember statutory authority and prescription, and never forget that coming to the nuisance is a dud. For remedies, think Coventry v. Lawrence and that balancing act. For Rylands, you need all 5 elements. And please, watch out for these common traps, especially mixing up planning permission with statutory authority. They are not the same thing. Imagine this. A client walks into your office, they're being sued for nuisance. What's your game plan? Well, first, you've got to know what defenses you can even raise. And second, you have to advise them on what the claimant could potentially walk away with.